I am really just thrilled to get to introduce both the lecturer and then just say a brief word about our lecturer before Professor Fuentes-Rohwer gives a formal introduction of him. So the Fuchs Lectureship in Law was established more than 20 years ago to honor the memory of Ralph Fuchs, a professor at this law school. He was a distinguished and respected member of our faculty from 1945 until his death in 1985. Professor Fuchs was an accomplished teacher and scholar and a pioneering scholar in the area of administrative law in particular. But he was equally well known for his lifelong commitment to public service and for the dedication and creativity and commitment that he brought to that work. He was the first chairman of the executive board of the Indiana Civil Liberties Union. He was active in the NAACP, and he was appointed to the State Committee on Legal Redress for that organization. He was also deeply committed to defending the rights of free speech, free press, and free assembly in the university context, eventually becoming the president of the American Association of University Professors. The yearly Fuchs Lecture, in many ways, is one important cornerstone of a wide-ranging public service commitment of this law school. From the work done through our live client clinics and our pro bono projects, and through the hard work of our vibrant student organizations, that commitment shines through. And I am really, as you know, all very committed to that work. Each year, that work is recognized in our annual Access to Justice sponsored award ceremony and tomorrow's pro bono award ceremony, which recognizes that this law school commits thousands of hours of work to our many communities each year in pro bono work. So we're really grateful to all of our students who perform that work and bring you this lecture partially as inspiration for it. Past Fuchs lecturers have included some of the nation's top lawyers and legal scholars, as well as those with deep commitments to public service. They include Sir David Williams of Cambridge University, William B. Gould, who was the former chairman of the National Labor Relations Board, Morris Dees, a civil rights lawyer and co-founder of the Southern Poverty Law Center, UCLA law professor Ingrid Early, Harvard Law School's Richard Lazarus, and last year's lecturer Ajay Mehrotra of Northwestern Law School. So it is really an honor to get to add to that list today's distinguished speaker, John Bonifaz, who is the co-founder and president of Free Speech for People. Professor Fuentes-Rohwer, as I mentioned, will provide a formal introduction of John Bonifaz in just a moment, but I want to take just a minute to thank John. John's father was the original lawyer on a case originating from mass-scale contamination in the Amazon region of Ecuador. And that case sought to employ the Alien Tort Claims Act to seek redress for those horrific harms. I met John because he was working as a side hustle for his father at that point to raise awareness about that case. And I had gone to law school because I was inspired from similar harms that I witnessed in Nicaragua and was committed to using the law and a law degree to work toward alleviating those types of harms. And John, completely unbeknownst to him when he came to talk about that case, inspired me and helped me helped secure a person who was really not sure that law school had been the right choice, helped to assure me that in fact it was exactly the right choice. And so in a way that entirely unknown to him, in a side hustle gig, he really played a really fundamental role in my legal law school career and also in my professional career. So thank you, John. I'm deeply grateful for that. I say that, I mention all of that, both obviously to thank John, but also because I know we talk regularly about two important truths that I want to highlight here. One is that you can never know the impact you are having on people, which is the reason that it is critically important that you are always conducting yourself with the highest level of professionalism, generosity, and kindness. A different interaction could have really actually sent me out of law school. And so, really in ways that you can just never fully appreciate, how you conduct yourself really impacts the people around you. I also mention it because of course that case was a groundbreaking case. It was novel in its employment of the Alien Tort Claims Act, in its efforts to attempt to protect people who were among the world's most vulnerable, suffering truly horrible harms. And that knowledge that the law has to be available to the most vulnerable in our society is fundamental to the rule of law. And so I mention it for that reason as well, to thank him for the work he's done on that case, but as you will see in many other ways as well. So with that, I'm going to cede the floor to Professor Fuentes-Rohwer, who will provide the more traditional introduction.
She called it the more traditional introduction. She took half my stuff. Regroup. Good afternoon, everyone. Thank you. Actually, first, let me just tell you, it's my great honor to introduce to you our endowed lecturer, John Bonifaz, whom I just met yesterday. And what a thrill. First, many thank yous. One, Dean Ochoa, for all that you do for Maurer. I couldn't be more thankful for all that you do. Thank you. Thank you, John, for coming to Bloomington to deliver the lecture. Thank you, all of you in the audience, for making time on this beautiful day. You made a great choice. I am not thinking about the pizza, by the way. Here's what I'm thinking about. John Bonifaz is a leading figure in the law and democracy space. I could tell you about some of his cases, such as, for example, cases on campaign finance, voter intimidation, ballot curing and voter purging, voter suppression laws generally, ballot access laws, but I don't have that kind of time. I could tell you about all the amazing work he's done in the human rights space, but apparently I can't do that anymore, so I won't do that. I had a story about how they met, but you heard it, so I'll skip that, go scroll. And of course, I don't have that kind of time either. Here's what I want to tell you, which is just tremendous. Not that the others are not, but this just moves me in different ways. Do you remember the spate of cases decided or filed under Section 3 of the 14th Amendment, known as the Insurrections Clause, before the 2024 election? John was behind many of those, if not all of them, either as counsel or friend of the court. Here's another one, my personal favorite. I teach constitutional law, which you should know is the hardest course to teach in the law school. When we discuss congressional powers, I love to bring up Article 1, Section 8, Clause 11. It's in here. It's called the War Powers Clause. It says quite explicitly, I won't bore you looking for it, it's in there. It's explicit. It is Congress who declares war. Then I ask in class, it's great fun, who declared, or actually I don't say that, I say, have you heard of the Vietnam War? Have you heard of Grenada? Have you heard of Iraq? And most students nod. Have you heard of any war dating back to 1942? And they say, I've heard of a bunch of them. And then I ask, who declared war in those cases? And I bet you know. They don't. I bet you do. Not Congress. What's going on? That would be the right question. By the way, last time Congress declared war at all was 1942. Well, there's a case that challenged that, the Iraqi war, the Iraq invasion in 2003. That case was John Doe 1 versus Bush. John was the lawyer in that case. He was behind that. So now I have a case to put with my class hypo. I appreciate that, John. A few more things I want to tell you, I'm wrapping up. He's a co-founder and president of Free Speech for People, an organization founded on the day the court decided Citizens United in 2010. Free speech for people advocates, among other things, for the right to vote, for free and fair elections, for reliable and secure voting systems, and for political equality to all. He also founded the National Voting Rights Institute in 1994, which he left in 2005 to join Voter Action. He's a graduate of Brown University and Harvard Law School. Last thing I will tell you is that John is a genius. You are. A MacArthur genius, not the Mensa kind. Though he may be that. I didn't ask him. How do you ask that question? Are you a genius? What's your IQ? I couldn't bring it up. And ChatGPT wouldn't tell me, so I don't know. But he's the MacArthur genius long ago, which is so impressive. So with that, please join me in welcoming John Bonifaz. I am super excited to hear what he has to say. Welcome.
Thank you so much, Luis, for that generous, very generous introduction. And thank you, Dean Ochoa, as well. I am honored to be here and be invited to give this lecture and to be visiting with all of you today. I'm going to, in my remarks, address three threats to American democracy today and ways that we can confront those threats. First, focusing on fighting big money in politics. Second, protecting the right to vote in our elections. And finally, confronting corruption and abuse of power from the executive branch. I'll start on the first one with the story of how I got into this field of fighting for democracy as a lawyer. And it really begins with a conference that took place in 1990 in Waveland, Mississippi, which I did not attend, but was brought together by a group called the Working Group on Electoral Democracy. And activists from the civil rights movement, from the environmental movement, from the peace movement, all gathered in Waveland to discuss this question of money in politics as a voting rights issue. And Dr. Gwen Patton, who was a longtime civil rights worker from Montgomery, said at that gathering, "We have fought and died for the right to vote, but what good is that right if we do not have candidates to vote for? Getting private money out of politics," she continued, "is the unfinished business of the voting rights movement." And that statement crystallized for those there the aim that they had to really try to focus the question for the legal community. None of them were lawyers, but to focus the question for the legal community on whether there could be a different lens applied to the campaign finance question from a voting rights perspective. So they set out to draft a memorandum outlining why they thought this idea should be explored by lawyers and law professors, and they sent it around the country to lawyers and law professors trying to get some interest in developing this further. And I happen to know one of the people in that group, his name's Randy Keeler. He was a founder of the Working Group on Electoral Democracy. And in the summer of 1991, as I was an incoming third-year law student, I got a hold of their memorandum. And I wrote Randy back and I said, you know, I'm not yet a lawyer, but I'm interested in exploring this as my third-year paper in law school. I wanted my third-year paper to be devoted to helping a social change movement, and would that work? The same day that my letter arrived, a letter came back from a long-time tenured law professor at Harvard, whose name I won't mention right now, who said, this is an entirely frivolous idea. This would actually be Rule 11 sanctionable if anybody brought it into a courtroom, and I wouldn't even advise a student to write a paper on this subject. So I didn't approach him to be my advisor for my third-year paper. I had a visiting professor there be my advisor, and I set out to explore this further in that paper. That ultimately led to my joining with then law professor Jamie Raskin, now Congressman Jamie Raskin, in co-authoring two law review articles, one for the Yale Law and Policy Review, the other for the Columbia Law Review, where we argued that today's campaign finance system is a wealth primary system. Like the white primaries of the past, it is exclusionary. And like the poll tax and candidate filing fees of the past, it is discriminatory. And we argue that it violates the Equal Protection Clause. So our goal with those pieces was to highlight that we need to move away from solely looking at this question from a First Amendment perspective and expand the lens to look at it from an equal protection perspective. The wealth primary today is as entrenched and as exclusionary and as discriminatory as it was when we wrote those pieces in the early 1990s. We also highlighted in those pieces why we saw the Buckley v. Vallejo ruling, the 1976 Supreme Court ruling that set us on this current course of unlimited campaign spending, why we saw that ruling as wrongly decided. That was a ruling which struck down campaign spending limits established in the wake of the Watergate scandal, and said effectively that money equaled speech and that there was a right by wealthy individuals to essentially drown out the voices of ordinary voters. We saw there to not be that right, and we made that argument in those articles as well. But 30-some years later, we now have an even worse system when it comes to the wealth primary, and no small part that is because of Citizens United, the 2010 Supreme Court ruling, which equated corporations as people with political speech rights, sweeping away a century of precedent, barring corporate money in our elections. Jeff Clements, another attorney, and I co-founded Free Speech for People on the day of the Citizens United ruling. We saw the writing on the wall from the re-argument that occurred in the fall of 2009, and we wanted to be prepared the day the court would go over the cliff with a campaign to amend the Constitution, to overturn that ruling and the doctrines underlying that ruling of money equaling speech and corporations being treated as people. Corporations are not people. They are artificial creatures of the state. They have state-based privileges that you and I do not have. Limited liability, perpetual life, the ability to aggregate wealth and distribute wealth. And for those reasons, they do not have constitutional rights. And this doctrine, fabricated doctrine of corporate constitutional rights that has existed since Lewis Powell's memorandum in the early 70s, needs to be overturned. So there are two amendments, among others, that we support at Free Speech for People. One of them is the Free and Fair Elections Amendment that Congressman Jim McGovern of Massachusetts has just reintroduced, that would overturn Buckley, that would allow for campaign spending limits to be set via Congress enacting them, allow the states as well to set reasonable campaign spending limits, but that would also end the fiction of corporations having speech rights in our political process. But there's also the companion amendment that we've advocated for that Congressman McGovern has also previously introduced, which would overturn altogether that fabricated doctrine of corporate constitutional rights. But short of a constitutional amendment, which definitely is a longer haul, though many states already across the country have demonstrated their support for that call, and Jeff Clements has gone on to start American Promise, which is an organization I highly recommend that's working with grassroots activists all across the country to advance the constitutional amendment fight. But short of that, there are other reforms that we can advance that do not require overturning Citizens United or Buckley v. Vallejo. And I'll just touch on a few of them. First, there's voluntary public funding systems. These are systems already in place in Arizona, in Maine, in Connecticut, in the cities of Seattle and New York and other places that provide public funding of elections to candidates who demonstrate that they've reached the qualifications to receive those funds. These are floors that allow candidates into the process. People who do not have access to wealth or wealthy interests or choose not to participate in the wealth primary process can access these public funds. It's a critical reform and needs to be advanced elsewhere. The other two I'll mention are ones that we're directly involved in at Free Speech for People. First, dealing with foreign influence corporate spending. We have been advancing model legislation for several years now to end foreign influence corporate spending in our elections. You may remember when President Obama gave his State of the Union address, for those who are watching, in 2010, right after the Citizens United ruling, he addressed the justices who were seated before him about Citizens United. He criticized it, and he said it would lead to foreign influence in our elections. And Justice Alito famously broke decorum. They're supposed to, the justices are supposed to sit there, not clap, not say anything. He famously broke decorum, shook his head, and mouthed the words, "not true." Well, in fact, President Obama's prediction was proven to be true, not just with the way in which we saw the Russian government interfere with the elections in 2016, but the way in which foreign investors can now subvert existing federal law that bars foreign nationals from spending money directly or indirectly in our elections through the corporate form. And so what this bill does is to close that loophole, to say that foreign influence corporations, corporations that have significant foreign investment, shall be barred altogether from spending money in our elections. The precedent we rely on for this, not just the longstanding precedent of the law being in place, is the ruling that upheld that law in Blumen v. FEC. This was a case brought by a Canadian citizen who, after Citizens United, said, well, if a corporation can spend from their general treasury funds, why can't I, as a Canadian citizen, go ahead and spend my money? He wanted to spend some $50 on leaflets for then President Obama's campaign. He challenged the law, and he lost. And then Judge Kavanaugh, the DC Circuit, wrote the opinion that upheld the longstanding ban on foreign nationals not having any role in our elections directly or indirectly. And he applied a very different interest than the interest that Buckley and Citizens United applied with respect to corruption and the appearance of corruption. He applied the interest of preserving American self-government. And the Supreme Court affirmed that ruling in Blumen v. FEC. So that is a critical precedent for this model legislation. It preserves American self-government to bar foreign influence corporate spenders in our elections. The other initiative I'll highlight that we've been working on is to abolish super PACs. And we've been working very closely with Professor Lawrence Lessig at Harvard Law School and his group Equal Citizens on this initiative. It is commonly misunderstood that super PACs emerged directly out of Citizens United. They did not. They emerged out of a DC Circuit case known as Speech Now v. FEC. And in that case, the DC Circuit, just 2 months, March 2010, 2 months after the Supreme Court ruling in Citizens United, they said, well, if independent expenditures cannot corrupt, as the Supreme Court in Citizens United said in dicta, then unlimited donations to independent expenditure committees cannot corrupt. That was their reasoning. And then Attorney General Eric Holder made the decision not to appeal that to the Supreme Court, finding that it would only affect a small subset of federal super PACs. That assumption, of course, is proven to be unfortunately wrong. It has become the vehicle, the main vehicle, for the exponential growth we see today in our elections of billionaires and wealthy interests dominating our politics. And the very question, 15 years later, of whether unlimited donations to super PACs corrupt the political process needs to now be put back before the courts. So we've been engaged in this in different venues, but the most recent one is one coming out of the state of Maine. where Professor Lessig and Equal Citizens catalyzed a ballot initiative this past November that 74% of the voters supported to set a $5,000 limit on how much you could give to a PAC. That effectively abolishes super PACs because by definition, they're the ones that take unlimited donations. That case is now before the First Circuit. The case that emerged out of that, 2 super PACs have challenged the law. We are involved in filing an amicus brief before the First Circuit, but the argument here is a very factual one. There's a 15 years of history demonstrating how unlimited donations to super PACs corrupt the political process. Do they now justify these limits? Elon Musk is exhibit A of why this is true, but also former Senator Bob Menendez is an exhibit because he was convicted on the very issues associated with the corrupting influence of super PACs. So I think the argument is very strong and why we need to advance that initiative as well. That's the area of big money in politics. On the question of protecting the right to vote in our elections, there are sadly forces in this country who do not believe in the vision of a multiracial democracy. And so they have set out to engage in voter suppression and voter intimidation over the past several years in ways that need to be confronted. We saw this right after the 2020 election, where as a result of the big lie advanced by Donald Trump and his cohorts, that there was massive fraud in the 2020 election with zero evidence showing that. All the cases that were brought alleging that all were found to have not shown any facts whatsoever demonstrating that fraud. Nevertheless, that big lie fueled new laws in Arizona and Texas and elsewhere that would engage in targeting, in particular, communities of color, traditionally disenfranchised communities, and try to make it more difficult for them to vote. These are voter suppression laws. And we're engaged with many others in challenging these laws in the courts in Arizona and Texas. And civil rights organizations are plaintiffs along with voters like the NAACP, like Mi Familia Vota, like the League of Women Voters. But I'll focus in particular on the voter intimidation schemes because those, I think, are even more prevalent in terms of their danger for our elections. In 2020, right before the election, we learned from a Washington Post article that a Tennessee company was advertising on military sites for ex-special forces. They were trying to recruit ex-special forces to be hired to show up at polling places in Minneapolis and St. Paul to, in their view, guard against Antifa and Black Lives Matter. Armed agents that they wanted at the polls. And the CEO of this company was happy to talk to this Washington Post reporter about this plan. And the reporter had seen these ads on the military sites, which is why they reached out to the CEO. And we got a hold of this article, as many others did, of course, and we decided there needed to be a challenge directly to this before the election. Section 11B of the Voting Rights Act makes clear that voter intimidation is strictly prohibited. This is a section of the Voting Rights Act that often is used by public authorities to enforce this prohibition, but in recent years, private parties have litigated under it as well. And we have done that at Free Speech for People. So we brought, on behalf of the Council on American Islamic Relations of Minnesota, the League of Women Voters of Minnesota, a challenge to this voter intimidation scheme. And within weeks, a federal district court judge, a Trump appointee, issued an injunction against this company, barring it from carrying out this scheme of sending armed agents to the polls under Section 11B, but also agreeing eventually to a consent decree, barring it from doing it through the 2024 cycle. The most recent victory I'll cite on this is out of New Hampshire. This was a case we brought under Section 11B and state statutes dealing with a scheme that was initiated by a political operative who, with robocall companies, sent thousands of robocalls to Democratic voters on the eve of the presidential primary in New Hampshire in January of 2024. And the robocalls had an AI-generated voice mimicking the voice of President Joe Biden. And it sounded very, very real, as AI can do. And it had, this voice, mimicked voice of Joe Biden saying, save your vote. Don't vote in the primary, save it for the general election. With the clear implication being that if you go ahead and vote in the primary, you will lose your vote in the general election. This was coercive, coming from the President of the United States, people thought. It was deceptive, and it was intimidating. And so we brought this challenge to both the political operative who initiated this and the robocall companies who allowed it to be broadcast and sent to thousands of voters. Legal women voters of New Hampshire, legal women voters of the United States, and individual voters of New Hampshire are our clients in this matter. We recently announced a major consent decree with the corporate defendants in this case, which the district court approved. And the corporate defendants admit that this call could have been intimidating to voters, and they're putting in compliance measures to ensure that they never send out this kind of robocall again. The remaining part of the case is with the political operative, Steve Kramer, who initiated this. He has chosen not to show up at all in court, so there's a default judgment motion pending against him, and we expect this to be resolved soon. But I share these two victories to highlight that we need to be vigilant in protecting our right to vote and dealing even with these kinds of voter intimidation schemes as they emerge in real time, potentially weeks before an election, where they can wreak havoc on the electoral process. Finally, we come to the third threat that I highlighted, which is confronting corruption and abuse of power out of the executive branch, particularly the White House today. The framers were clear. The framers were clear that there would be no monarchs, no tyrants who would govern our nation, no kings in America. And they set out in the Constitution to establish three co-equal branches of government to ensure that. Article 1, establishing the United States Congress. Article 2, establishing the presidency. And Article 3, establishing the judiciary. Three co-equal branches of government, no kings in America. But they added an extra guardrail to deal with that possibility of a president who would so trample on the rule of law, so trample on the Constitution, that that president would need to be held accountable through an impeachment process. Section 4 of Article 2, the impeachment clause. And today we face that moment of a president who has so defied the rule of law, has so trampled on the Constitution, that he must face impeachment and removal under Section 4, Article 2. We have launched at Free Speech for People impeachtrumpagain.org. More than 1 million people all across the country have joined us in this campaign, signing on to our petition. And we have been documenting at that site in detail the multiple abuses of power that Donald Trump has committed since assuming the oath of office in January of this year. 25 distinct grounds for impeachment is our current number. I'll just cite a handful of them. Disappearing people from the streets, sending them to foreign torture prisons, an abuse of power, an impeachable offense. Removing U.S. residents, detaining, arresting, and removing them without any due process of law, an abuse of power, an impeachable offense. Mobilizing the United States military into our cities, levying war against the United States, against individual states, against their people, committing treason, the highest crime of the impeachment clause, an impeachment, an abuse of power, an impeachable offense. Usurping Congress's authority to appropriate money. Article 1 establishes only Congress has the authority to appropriate funds, and yet the president and his cohorts have gone ahead and frozen trillions of dollars of public funds that have been duly appropriated by Congress. An abuse of power, an impeachable offense. Defying multiple court orders issued by federal courts all across the country. Usurping the judiciary, an attack on the judiciary, an abuse of power, an impeachable offense. Unconstitutionally and systematically violating the First Amendment, extorting law firms that are engaged in taking on clients that the president doesn't like, engaging in attacks on academic institutions, seeking to have Jimmy Kimmel removed from the air. The list goes on the attacks on the First Amendment from this president. Abuse of power, an impeachable offense. Abusing investigatory and prosecutorial powers. The sham indictment of James Comey. The sham indictment of Letitia James. Selective prosecution, vindictive prosecution. Abuse of power, an impeachable offense. Engaging in corruption, rampant corruption in the White House, treating the Oval Office as a profit-making enterprise at the public expense, violating the foreign and domestic emoluments clauses, refusing to divest from your business interests all over the world. An abuse of power, an impeachable offense. Pardoning 1,500 plus insurrectionists who you incited, the president, to attack the U.S. Capitol on January 6, 2021, to try to stop the peaceful transfer of power, an abuse of power, an impeachable offense. The list goes on, and as I said, we've documented this in detail. Now, I understand, perhaps in this room or with your friends and neighbors, that people will say, well, we need to move on from impeachment. We just need to move on. He was impeached twice. He wasn't convicted. This is political. You know, we shouldn't engage in this kind of activity. Or now is not the time. Now is not the time to talk about impeachment. We have three responses to this. Number one, we either have a constitution or we don't. We either have an impeachment clause or we don't. If we're not going to enforce the impeachment clause at this critical moment in our history, then we might as well say we are giving up on the United States Constitution. We refuse to give up on the Constitution. Number two, when we do not name this conduct for what it is, we normalize it. These are not policy disputes. This is not about whether we are cutting Social Security or not. This is not about whether we're cutting Medicare or not. Those are policy disputes. These are high crimes, political crimes against the state, and we must name them for what they are. And number three, members of Congress take the very same oath that Donald Trump took on January 20th, 2025. to protect and defend the Constitution. They have a duty, a sworn duty, to do that, to invoke the impeachment power and to demand impeachment proceedings against this lawless president. And Congressman Al Green from Houston, Texas, has already shown he's going to abide by that oath. He has already introduced articles of impeachment, and as you know, he forced a vote in June of 2025 on the floor of the House of Representatives. We were proud to work closely with him in drafting those articles. It dealt with the violation of the War Powers Clause with respect to the illegal bombing of Iran. And 78 of his colleagues joined him in voting to advance those articles of impeachment. That number was nearly quadruple the number prior to that vote who were on record for impeachment. And as he and others, we hope, advance new articles of impeachment, we expect that number will only continue to grow. The last area of taking on corruption, abuse of power in the White House that I want to just highlight is around the role of state and local prosecutors. They too have a sworn duty. And in Trump v. United States, as we know, there was presidential immunity applied for the first time to what the court deemed official acts. But it was not defined. Official acts were never defined. And Special Counsel Jack Smith, as you may remember, was determined to continue to litigate the case underlying Trump v. US back in the district court because he argued that none of the charges in the indictment dealing with the insurrection, dealing with the efforts to overturn the 2020 election, none of them were official acts. And he was prepared to make that argument back before the district court. But he didn't have the chance to do that, of course. He no longer is special counsel, and that case has been dismissed. But the issue remains that a president who is not engaged in official acts must still be held accountable for violations of state criminal laws. We know the Justice Department, sadly today, is not going to engage in enforcing federal criminal laws against Donald Trump. They are an arm of Donald Trump. They are a private law firm, effectively, for Donald Trump today. In fact, he's now got a petition, as you probably saw in the news over the past 24 hours, for $230 million of compensation that he has pending before the Department of Justice. And shock will it be whether or not they grant that petition. But the states have a role here to enforce their own criminal laws with respect to crimes that Donald Trump and his cohorts are committing. Extortion. The 9 law firms that have been extorted nearly $1 billion, these are direct violations of state criminal laws. We have written to the state attorneys general and local DAs in California, New York, Illinois, Pennsylvania, and Massachusetts, all urging criminal investigations into this extortion scheme. And the kidnapping of Romesa Ozturk in Massachusetts off the streets of Somerville, a Tufts graduate student taken thousands of miles away to Louisiana, in detention for months illegally. We've urged the Massachusetts AG in a letter to open a criminal investigation into that kidnapping and the kidnapping of Kilmar Abrego Garcia in Maryland. We've issued a letter to the Maryland AG. AGs and local DAs have a role to play here in upholding the rule of law and upholding our Constitution. And I'll just end here with the title of this speech, at least in part, A Republic If You Can Keep It. As you, I'm sure, know, a woman named Elizabeth Willing Powell asked Ben Franklin on the last day of the Constitutional Convention in September 1787, well, doctor, what have we got? A republic or a monarchy? Franklin responded, a republic, if you can keep it. That warning by Ben Franklin is no more relevant, is as relevant today as it has ever been. A republic if you can keep it. We will fight to keep it. We will stand up. We will be heard. We will abide by our oath as current and future officers of the court. We will stay vigilant and fearless in the face of any threat of tyranny, because our democracy and our Constitution depend on it. Thank you.
John. So just a quick announcement for virtual attendees seeking CLE credit for the lecture. The number is 57528, and that will be placed in the chat, wherever the chat is. You should see it there, 57528. It's a reminder for those of you here who want CLE credit, there's a sign-up sheet in the back, or actually outside the room, at the double doors. Please sign up to receive credit. And the attendance code is only for the attendees online, not for you in person. Now we have a moment for questions. Happily, you'll see we don't have microphones, which is both good and bad. It's good because we don't need microphone. You can just stand and ask your question. We can hear you. The bad is that you see those green things up on top. We're always listening. Now we can hear you. So that is to say, if you have a question, please stand up and ask. And then you can just call them.
Yes, in the back.
Do you see a role for bar associations to disbar Trump's lawyers?
Yeah, great question. The question, for those who didn't hear, is do you see a role for bar associations to disbar lawyers who are engaged in misconduct in the Trump administration? We do, and in fact, we're not alone. There are a number of groups that have filed complaints before different bar associations, including a complaint pending in Florida against Pam Bondi with respect to misconduct. And, you know, this is not something that only advocacy groups are discussing. There are judges who have questioned whether Trump attorneys, Trump administration attorneys, are being faithful to the law and truthful when they appear before those courts. So this has come up in a number of different hearings, and it is a serious matter. If you're not abiding by your own oath as an officer of the court, you should, I believe, face those kinds of proceedings. Thank you for that question. Yes, sorry, thank you.
So with the number of lawyers that are actually in Congress, in the Republican Party, what do you think is this like a Trump-specific issue? Is this actually related to sort of politicization of the party's polarization when it comes to the executive branch overstepping so far? I wonder, for example, like what the memos within the Republican Party are looking like on these issues as to the actual constitutionality of their actions.
Yeah, so the question is, you know, what is exactly the essence of where this is coming from within the Republican Party or in Congress in general with respect to these actions? And, you know, we of course don't have access to any of those memos if they in fact do exist. But what I will say is that I think, you know, we have a joint problem. We have one party that refuses to question whatsoever the president, with very few exceptions, and that's his own party within Congress. But then we have another party in Congress that, by and large, does not want to invoke the very power, the very constitutional remedy the framers put there to deal with this kind of crisis. Other than Congressman Green and the 78 who then voted with him on those articles of impeachment, this has been seen as a question that shall not be discussed. The I word shall not be mentioned within the Democratic caucus. There was a Michigan congressman who introduced articles of impeachment, and he wanted to bring his articles to the floor, and he was quickly shut down and told, we're not going to do that, and he backed off. Thankfully, Congressman Green did not. But, you know, I think we're dealing with a joint problem. We're dealing with both parties not engaging in abiding by their oath. I don't, I can't imagine what constitutional arguments there would be to defend all these different actions that I've cited that Donald Trump has committed and many more. We don't see a basis for it in the Constitution. If anything, it's a basis for his removal. But I think sadly, what we're not getting at all is any level of challenge to this abuse of authority here and now. There are plenty of people who will say, we just have to wait until the midterms, and wait until January 2027, and then we're going to see that kind of challenge emerge. The problem we have with that idea is that you got to build this case for impeachment now. You can't all of a sudden 2 years after having not built it in January 2027 say, guess what, we're going to start talking about this. 2 years of trampling on the Constitution, you didn't say anything, now we're going to start talking about it. We think that's not a good strategy and frankly not adherence to the Constitution. So we're seeing it from both sides of the aisle in Congress today. Yes.
So you spoke sort of briefly about just in terms of abuses of power by Trump, like intimidation of free speech on college campuses and how that's kind of created a culture of fear and resistance to any criticism and just curtailing free speech overall. I think that's something we're certainly dealing with here at IU. I'm not sure how familiar with that you are, but I guess what do you think is like the proper response of, I guess, students especially to those free speech challenges at universities around the country?
Yes. So the question, very important one, is what is the response students should give to the attack on the First Amendment on college campuses? And I did happen to read about what happened here recently, and I salute the co-editors of the paper for their bravery. And I do think that students have a critical role in standing up to these attacks and making clear that the First Amendment will not be trampled on without this kind of response, which makes clear that we're not going to cede and give up on the First Amendment. I think that the Jimmy Kimmel moment was an important moment, right? But we also have to recognize that it was in part a moment where a lot of people started canceling their Disney subscriptions, and that woke the company up. But it was also a critical moment for people to make clear that they're not going to stand it. They're not going to take it. They're not going to allow this constant barrage of attacks on the First Amendment. And there should be no other place in our society for where we honor and embrace the First Amendment than on the campuses at academic institutions, the places of learning. That should be where we have this robust set of ideas, whether it be about ICE, Palestine, or whatever other issues people want to speak about. But those are the ones that, of course, have been targeted. And we know that this sending of the military into the cities is also about trying to quell dissent, squelch dissent, and block people from peacefully protesting ICE's actions. So I think we're in this moment where we all need to stand up, and it's a hands-on deck moment, and I do think students have a critical role in speaking out against that. Thank you for that question. Yes, in the back, and then we'll, yes.
Don, actually, by all means.
Oh, no, you go. I'll go next.
This is really wonderful. So the question I have, I was struck by the example of your incredible litigation involving the robocalls with the AI-generated Joe Biden voice. And the question I have goes to kind of now bringing it to the contemporary day, where the entrance barriers for AI have drastically reduced, knowing, of course, the interconnectedness of our ecosystem, including the ability for foreign actors to use similar
Yes,
techniques.
yes.
What kind of strategies or thoughts do you have about how to aggregate and make that kind of litigation more possible, whether in private hands or working with attorney generals and so forth, this is clearly a different issue.
Yes. So I'll just repeat it for those listening on Zoom. A very important question. What are the strategies for dealing with the threat of AI in our elections going forward with respect to either state AGs or private parties? What more litigation can be done? And, we brought this case knowing that it would maybe be the first, but we haven't seen another case brought dealing with this kind of threat of AI in our elections, but we knew it wouldn't be the last. We knew there would have to be others. We sought to establish this precedent, which we're hopeful is going to be established here, that this kind of interference and disruption of the political process using AI needs to be prohibited. But I think we can't stop there. We obviously have to deal with legislation as well. And California, as you may know, has enacted legislation that's now in the courts that deals with the threat of AI in political advertising and where it's disinformation. And I also, as I mentioned, think Section 11B is a powerful tool that needs to be continued to be used by litigants. We're not going to get the DOJ to do it anytime soon, but state AGs can use it, as can private parties. I think the biggest challenge we have with all this is that, just like we saw with the New Hampshire example, to stop it days before, in that case, I think it was 72 hours before the primary, it's nearly impossible. The robocalls had already been issued, the deception was out there. And so that's where there has to be a vigorous enforcement of the law in real time, but also having more state laws enacted that allow for that. Thank you for that question. Dawn, yes.
Just very quickly, so you clearly take on very ambitious goals that are not immediately attainable, like amending the Constitution, impeachment, and I think your list of, I'm looking forward to look at your website and the list, and I think it's so valuable to list specific abuses of power in one place like that. I'm wondering, in the context of litigation, how much you consider that the Supreme Court currently is not open to your arguments on issues of, on some of your arguments, I'll say, campaign finance and First Amendment, and how restrained you feel or you think others should be in bringing cases to the Supreme Court?
Yeah, thank you for that question. And I think most heard it here about, just repeat it for the Zoom audience, what considerations in litigation are we making given the current Supreme Court in terms of bringing cases that could end up before the Supreme Court in this current makeup that we have. I think it's an important consideration. We definitely do weigh it. I will say, in the campaign finance arena, the two initiatives that I highlighted around ending foreign influence corporate spending and abolishing super PACs, in our view, the court affirming that super PACs are here to stay doesn't set us back. It establishes where we already are. So we don't see there to be a danger in creating bad law. The bad law is already there through the Speech Now decision. With respect to ending foreign influence corporate spending, that loophole has been driven through multiple times already, post Citizens United, despite President Obama's warning. So there too, if the court were to find, as a district court ruling has already found, applying Citizens United and barring Minnesota from enacting this law, that that Citizens United bars this altogether, it would be status quo in our view. It wouldn't make bad law. But I do think it's an important consideration where there is not, that scenario of already the bad law being in existence. I will say there are other cases, of course, that don't reach the Supreme Court, right? And that's where, the New Hampshire case is an example, or the Minnesota case where, we're litigating Section 11B. I'm sure some justices would love to try to strike down Section 11B as well, but we're not litigating it with the goal of getting it to the Supreme Court. We know that others may try to, and we recognize there's that challenge, but we have to keep fighting in the courts where we can to apply the existing protections for our elections. Thank you.
That's a wonderful place to stop. Please join me in thanking John Bonifaz.